Hello, this nugget is part 2 of the Introduction to Shipping Finance, looking at the differentiating factors which make shipping finance different from other forms of finance. First, we look at the volatility of the shipping finance market. There are both demand-side and supply-side reasons why shipping is a volatile market. On the supply side, there are vast numbers of shipbuilders worldwide, and the construction of ships is often a key part of a country's economy, benefiting from government support or even subsidies. There's no inherent restriction on the numbers of ships which can be built, unlike aircraft with a much more limited number of manufacturers. It takes a long time between ordering a ship and its delivery fully ready for service. Because of this and the number of manufacturers, over-ordering of new ships does not become apparent for some time after it occurs, and there is therefore a tendency to oversupply. On the demand side, ships are the first to be hit by political and economic turmoil. If economies falter, they stop needing to transport so many goods and raw materials. If hostilities break out or sanctions are imposed, transport needs are affected immediately. Changes in fuel prices have a major impact on the economics of the ship's operation. These changes in demand occur very quickly, and it takes a while for the supply side to adjust. One fundamental issue to appreciate is the concept of liens. A lien is a security interest which attaches to a ship and to other assets such as aircraft. A lien holder has a right to arrest the ship and to require payment of the debt secured by the lien, if necessary, by sale of the ship. There are different types of liens: maritime, statutory, possessory, common law, etc., some of which have priority to a mortgage and others do not. In addition, different countries grant liens to different claimants. We've already seen an example of this in the area of sister ship arrest. Most maritime jurisdictions allow one ship to be arrested for the debts of another ship owned by the same company, that is, a sister ship, but in some countries the concept of a sister ship is much broader than in others. The other key point about liens is that they attach to the ship and will not be removed by a change of ownership. They are referred to as rights in rem, an interest in an asset, as opposed to rights in personam, which is a right to take legal action against a person. Moreover, there is no register on which liens must be entered in order to be valid. The ship's register will require registration of mortgages, but not other types of liens. The result of this is that a purchaser of a ship may find that it's arrested for the debts of a previous owner. There's no central register which can be searched to minimize this risk. For this reason, the purchase contract for a ship will invariably contain an indemnity from the seller to the buyer in respect of liens. In most countries, a court sale will be recognized as clearing off liens. Finally, mention must be made of the fact that a number of different laws will be relevant to determine the lender's rights, and in the event of security enforcement, their ultimate recovery. Ships are required to be registered under the law and nationality of a particular country. The requirements for registration are discussed elsewhere. The law of that country then determines how a mortgage on that ship can be effected and what rights it gives to the mortgage holder. The ship owner may be incorporated in a different country, and the laws of that country will determine company law issues such as the power and duties of the directors of the company, such as the authority of the directors to authorize the borrowing of money. As already mentioned, the ship will also be subject to operational requirements such as port state control in the different places where she visits. The liability of the ship for damage which it does, such as environmental liability, will depend on where she trades. Ultimately, the enforcement of the ship's security will also be conducted in accordance with the procedures and other requirements of whatever country the ship happens to be in when enforcement occurs. Finally, the ship owner may also be subject to insolvency laws in countries with which it has a connection. Where the ship owner is a special purpose company whose only asset is the ship, insolvency procedures are rarely instigated because claiming directly against the ship is far simpler. Nevertheless, if the relevant insolvency law could produce a better result for the company or its other creditors than simple claims against the ship itself, they can be expected to try to take advantage of those laws. For example, if the relevant insolvency law provides for a compulsory rehabilitation procedure for companies in difficulty, freezing the enforcement of claims while negotiations proceed, a shipowner may well seek to take advantage of that to prevent, or at least delay, enforcement of security. Similarly, if a liquidator would be able to challenge the grant of security on the grounds that it was unfairly prejudicial to other creditors, for example because it was a preference, they can be expected to do that. Again, if the relevant country would allow debts incurred by other companies to be claimed against assets of this company, this is commonly referred to as piercing the corporate veil and could happen, for example, as a result of the US concept of substantive consolidation discussed separately, then this risk must also be considered. The result is that the laws of many different countries need to be considered when the transaction is first documented, and a number of legal opinions will be obtained from these countries. Nevertheless, there is a limit to the protection which this advice can give to the lenders, since the place of enforcement, and even the place where insolvency proceedings may occur, cannot be predicted with any certainty.